start with YouTube, both. we
Okay.
Live lecture both Zoom system and YouTube system. So I couldn't connect to the Zoom, so now I connected. So we can heard your lecture both Zoom and YouTube channel.
Right.
Okay, now it's all right. Let me check. Okay, I started live YouTube channel. Now it's okay. Maybe I'm not sure whether it is going on or not, but just hold on, please. Okay, now it's going on. Okay, great. So now you can watch your lecture, both Zoom and YouTube channel. The technology was so much advanced.
Yeah.
So through this technology system, helper, we can communicate more deeply and interact.
Right.
It's very, very impressively.
Right.
Okay.
So can we have the English version of the presentation as well with this?
Okay. Now I will display your presentation. Just hold on, please. This is Korean. This is English.
Okay.
자, 그래서 이제 yes, now it's ready. 자,
Okay.
이제 now we start the lecture. So 다시 한번 인사드리겠습니다. 안녕하십니까? 인도 인문학 시민강좌 이병진 교수입니다. 반갑습니다. 오늘은 인도 뉴델리에 조교수로 계신 만주 아그라왈 교수님을 모시고 인도 법체계의 그 도전과 과제, The Brief Introduction about Indian Legal System, Challenge and the Road Ahead를 주제로 강의를 들어보도록 하겠습니다. 지난 시간과 마찬가지로 교수는 그 강의는 이제 영어로 진행하지만 지금 우리가 화면을 보고 있듯이 영어와 한글을 동시에 진행하도록 하겠습니다. 그리고 이제 토론 시간 좀 가지고요. 중간중간에 부연 설명이 필요한 부분은 제가 도움을 드리도록 하겠습니다. Okay. Now, let's introduce the Professor Manoj Agarwal. Good morning, sir.
Very good morning to all of you present here.
Yes, this is first time to meet Korean audience. So let me ask you to introduce yourself shortly.
Yeah, so I'm thankful to Professor Lee for giving me this opportunity, and Professor Indomat to coordinate this entire lecture. So I'm really looking forward to interact with the audience, which I believe is Korean people, and I have learned, are very much interested to learn about how Indian legal system operates. So this is a very brief introduction to the vast legal system that India has. There are certainly challenges with any system which is so vast and diverse as the Indian legal system is. So there are certainly challenges that India faces. And then every challenge presents an opportunity. So I'm sure there are ways in which technology shapes the road ahead to resolve some of the challenges of the Indian legal system. And I'm sure in the coming future, the legal system is going to evolve in a manner in which it resolves many of its challenges. Okay. So if you allow me, we can start the presentation, right? I've been allocated some time, and I've been told that my presentation is pretty lengthy. So I'll try to be brief and encourage discussion on any topic. Yes. that you feel is important.
네, 사전에 제가 아그라왈 교수님한테 부탁을 드렸는데, 우리가 이제 인도 법률가도 아니고 또 인도의 법 지식이 깊지 않기 때문에 어떤 특정 쟁점보다는 전반적으로 인도에 대해서 배경 지식이 없는 시민들이 인도의 어떤 법 체계를 이해할 수 있도록 그런 큰 틀에서 강의를 부탁드렸고요. 우리가 인도 법 체계를 살펴보고자 하는 이유는 지난 시간에 우리가 인도 사회를 통해서 알아봤지만 인도는 굉장히 문화도 다양하고 사회도 복잡하고 인구도 많습니다. 이러한 굉장히 그 복잡한 이러한 국가를 통합해서 하나의 어떤 체계적이고 일목요연하게 이끌어가기 위해서는 법 체계가 굉장히 중요합니다. 그래서 법이 인도 사회에 미치는 영향이 크기 때문에 전반적으로 인도의 법의 가치를 어디에서 근거하고 있는지 헌법적인 가치에서 찾아보고 그러한 내용을 통해서 우리가 좀 더 인도 사회를 체계적으로 이해해 볼 수 있는 의도에서 이렇게 시작을 했습니다. Okay, so shall I start your lecture?
Yeah,
We
yeah.
listen.
I think you can go to the next slide and start the lecture.
Okay.
So, as I said, India is a very big country as far as its population is concerned. It's going to be world #1 in population. It's soon. So we have a very huge population of 1.4 billion people almost, and we have a very diverse culture, diverse language, diverse religion, so many diversities and complexities to handle. So in India, no one legal system suits all. So we have multiplicity of laws, we have very many diverse situations to manage, and it is as if that we are taking bath in the holy water of Triveni, which is considered to be a juncture of Ganga, Yamuna, and Saraswati River, as we say. So Indian legal system is also accumulation of multiple disciplines, multiple diverse scenarios, and that is how it has evolved into a rich, diverse, and often conflicting legal system. So we will see what are the different branches, how India caters to its legal demand, and what are the challenges in this system.
Right.
So we can move to the second slide, which will detail the presentation a little more.
This is the second chapter.
Yeah, so Indian civil law. Civil law governs generally the civil disputes. So there are in our constitution mechanisms by which we resolve civil disputes. So civil law in such a hugely densely populated country becomes very important to resolve conflicts between individuals generally. So we have civil code, we have codes covering the corporate law, the administrative law, the tax law, the constitutional law, and it also enshrines the basic duties and rights that people of India have to obey, right? So the laws are primarily made in India by the legislature. So legislature, as India is a country which has a federated system, so there is a central legislature and there are state level legislature. Then the lawmaking duty or privileges are also enacted upon by the constitution to various different local bodies which are different arms of the state. So that is how Indian legal system has multiple hierarchical bodies to make laws, and that is how the entire legal system operates in India, right?
Yes.
So this is about civil law, a brief introduction of what Indian civil law looks like. We'll see in detail other branches of civil law as we move ahead in the presentation. So as we know, many countries of the world, including UK, follows the common law system. Now here, lawmaking is not only the work of legislature, courts also enact laws, courts also make laws. So common laws generally depend upon the precedences based on a case which has occurred previously in the history, and the rationality with which it was solved is taken over as a judicial principle to be followed by all lower courts. So Indian common law system also gives this power to the courts, Supreme Court, High Court, and subordinate courts to interpret and make, take decisions based on the precedences. So common law generally operates by way of developing reasoning based on precedents of previous cases having similar facts. So this is why India has adopted a common law system to deal
Okay.
with various scenarios that occur here. So customary law. Now, as I said, India is a land of customs. There's so many different culture thriving in India, and so many different customs, have been thriving here for, thousands of years. So every such, entity has its own laws. So Indian Constitution have respected the customary provisions of its people. So, a very important and significant part of Indian legal system depends on customary laws, right? So anything which has been continuing for many, many years becomes custom, right? And when it has been accepted as custom, the laws of the custom, are often used to resolve disputes originating in a particular community or within communities. So customary law is very, very important in India scenario. So the Indian legal system, the next slide tells you how the components of the Indian legal system operate. So as you can see in this presentation, at the top is the Constitution of India. Constitution of India is the guiding light for the entire legal system, right? It gives us privileges, it gives us duties, it gives us our rights, and is the central entity to which our legal system is based upon. So if you see this presentation, this is a very simplified version of what Indian legal system is, but it tells you all the important organs. So if you see, there's legislation which makes laws, the court of law which makes laws, and there are customs which help the Indian legal system to evolve its uh, uh, legal jurisprudence. So the idea is that the Indian legal system works by taking inputs from constitution, the court of law, the legislations, and the customs. So this is a kind of an overview of how the Indian legal system operates in its basic form.
Okay. Sir, let me give me 1 minute break.
Yeah.
Okay. So 지금 이제 그 교수님께서 설명해 주신 인도의 법체계에는 인도가 인구가 13억 8천, 14억이 가깝습니다. 그래서 이런 굉장한 그 다양한 사람들이 살고 있기 때문에 인도의 법체계는 굉장히 다양하고 복잡하다는 건데, 특징적으로 보면 우리처럼 민법, 그다음에 관습법이 이제 있는데, 여기서는 이제 시빌로, 그다음에 커먼로, 이건 보통 우리가 이제 일반적인 그 커먼로인데 요 관습법이라고 했는데, 그 커스텀러, 이 관습법이 이제 인도에서 상당히 이제 영국의 영향을 받아서 이 그 판례뿐만 아니라 문화적인 거라든지 종교적인 어떤 관습이라든지 이런 거에 또 법체계에 영향을 미치고 있다, 이런 특징을 우리가 알 수 있고요. 그래서 인도의 법체계는 헌법에 근거해서 여러 가지 법률, 규칙, 그다음 관습법, 성문화되지 않는 이런 관습까지 포함해서 아주 복잡한 법체계를 가지고 있다라고 확인해 볼 수 있습니다. Okay, now we are going to the Constitution, Indian Constitution.
So
인헌법에 대해서 이제 우리가 들어보도록 하겠습니다. Okay.
So as I said, the Indian Constitution is the most important document in India, which governs the entire functioning of the country and including its legal system. So the Constitution, the heart of the Constitution is the preamble, right? It is the guiding light which tells the entire country, the philosophy on which India Constitution is evolved, developed, right? So if you go through the first few lines, which is very relevant, and I'd like to emphasize on this, right? So if you see the first line, that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. Now, it is the people of India who have resolved to form India into a sovereign socialist is a form of government, as you understand, right, where state allocates resources largely. Secular means the state will not participate or have a religion, right, and it will be largely based on the principle of, I'm sorry, my laptop is running low on battery. Just let me
Okay. No, okay. Take it easy.
no, I forgot to plug in
네.
the
오케이. 지금 우리가 헌법에 대해서 전문을 이제 보고 있습니다. 좀
I'm
노-
good
Okay.
now. I think we have managed the situation. So sorry for the disturbance that occurred.
no, thank you.
Right. So the secular is a very important phenomena in Indian democracy. So that means the state will not favor any religion. The state will be religion free. It will be neutral, because India is a land of multiple religion, as you understand. And democratic is the government is for the people, by the people, and of the people, as you understand. India assures, or thrives to assure, if I may correct myself, justice to all its citizens. And justice has been defined not only in legal form, it is justice in the form of social, economical, and political rights. Similarly, liberty is given to each and every citizen in the form of thought, expression, belief, faith, and worship, so that nobody feels left out. Equality, similarly, in status and opportunity. And fraternity is to promote brotherhood and dignity, right? So if you read the preamble of India, it emphasizes such an inclusive society where it respects diversity, it respects equality, and promotes brotherhood and equality among all its citizens. So this is the guiding light, and everything that happens in India, whenever something goes wrong, this is the preamble which helps us to set it right. So this is a very, very important document, very, very important text for the entire legal system to help itself, resolve a conflict that often occurs in India, right? So as I said, this is the guiding light, and this will enlighten us throughout our discussion on Indian legal system. So
Okay.
we can move to the next slide. Yeah. So fundamental rights, the framers of our constitution believes that fundamental right and section in which it is enshrined 19 to 25 generally is the pulse of the Indian constitution. It is something which is very, very important, crucial, pivotal to the achievement of the goals in the preamble, right? So India gives its citizen certain fundamental rights, and the first among them is equality before law. Then there is equal opportunity of employment, prohibition of discrimination based on sex, religion, birth, any kind of discrimination that you may imagine of, protection of personal life and liberty. That means every person's life and liberty will be protected by the state, right? In similar manner, right to freedom of speech, freedom of forming association, movement. These are very important fundamental rights that helps Indian democratic system to evolve and get better each day. Similarly, freedom of religion is a very important right. Then there's special right to protect interests of the minorities. Since India, as I said, is a land of different cultures, different religion, different languages. So there are different types of minorities in India. It's a unique, country in that sense. There are linguistic minorities. There are minorities in form of caste, creed, religion. So minorities is very important in India. So protection of the interest of minorities is a very important fundamental right. And similarly, to enforce all these rights, the Constitution has given right to constitutional remedies, in Article 32. That means if any of the rights are violated by the state, an individual or group or an entity can approach the Supreme Court. And under Article 32, Supreme Court has the right to protect its citizens from encroachment of any of the fundamental rights if the state, does so. So,
Yeah.
this is very, very fundamental. This is very, very important for any democracy to give some rights to its citizens so that they can practice democracy, right, and democratic behavior. So this is very crucial to Indian Constitution. So this is about fundamental rights. We can move to the next slide. Writ jurisdiction. Often it has been observed that the state encroaches upon, or different arms of the state encroaches upon the rights of the individuals or groups or entities. In such cases, writ jurisdiction comes into play. As I said, Article 32 gives Supreme Court the power to enforce the rights if it is encroached upon by any arm of the state. In the same manner, writ jurisdiction, which is only the High Court and the Supreme Court in India, which can enforce this jurisdiction, invoke this jurisdiction, gives the right to these courts, to issue uh, directions to the state and the different arms of the state, so that fundamental rights of the citizens are protected, right? So this is a very, very important aspect, that the two higher courts in India, Supreme Court and the High Court, are given the responsibility through Constitution to protect and safeguard the human rights and other fundamental rights as enshrined in the Constitution of India. So this is very, very critical in Indian legal system. So we can move to the next slide. Now, this photo is the photo of the Indian Parliament. It is changing though. We are making a new parliament. India will soon have a new parliament. So this is the one we got after independence. Now this parliament houses two important legislatures. One is the Lok Sabha, another is Rajya Sabha. They are the central union government entities which formulate policies for India, laws for India. So Indian legislature, if you see, the central body or the supreme body to enact laws is Lok Sabha and Rajya Sabha at the level of Indian government. And then there are state governments. So you have state assemblies where state legislations are being made. Now, since India is a diverse country, it has 29 states and one union government. So often conflict arises as to which thing the union will make laws and about which thing the state will make laws. So Indian Constitution understood this, the constitutional framers understood this dichotomy, and they prepared three lists. One is called the union list, one is called the state list, another is called the concurrent list. So the union list is one where the union will only legislate. That means the Lok Sabha and Rajya Sabha has the only authority to formulate policies, laws based on items in the union list. Similarly, there is a state list in which the state has been given exclusive right to formulate laws, policies based on the items in the state list. And then there is a concurrent list, items which overlap both in the domain of state and union. So there is a concurrent list where state and union can simultaneously make laws. But if there is a conflict between the laws of the state and the laws of the union will prevail upon. So union has been given precedence on the state on the concurrent list. Otherwise, their functions have been kept as separate as possible under the Constitution so that they do not conflict with each other. So that is how Indian Constitution, separates power as well as gives a hierarchical system to India where laws are enacted by both the state legislature and the Parliament of India.
Yes,
Right.
okay. So let me give me 1 minute. 지금
Right.
우리가 인도 법체계를 이해하는 데 있어서 어떻게 법이 만들어지는 건가에 대해서 설명을 주셨는데요. 인도는 한국과 달리 의원 내각제입니다. 그래서 여기 설명에 해주셨듯이 유니언 레벨에서는 파리아먼트에서 연방 법을 만들고요. 그 다음에 스테이트 어셈블리라고 해서 각 주에 또 주의회가 있습니다. 그 주의회가 또 지방정부를 구성하게 되는데 이 주의회에서 그 법을 또 주에 관할하는 그런 법을 만들고, 그래서 이러한 법이 헌법에 유니온 리스트에서 연방의회에서 만들 수 있는 법률이 무엇이 있고, 그 다음에 주에서 관할할 수 있는 법률이 어떤 목록이 있는지, 스테이트 리스트라고 해서 헌법에 이런 리스트가 쭉 나와 있습니다. 그래서 이거에 근거해서 연방의회와 주의회에서 법을 만든다는 거. 동시에 이제 연방의회와 주의회에서 동시에 또 입법할 수 있는 것들이 있는데, 그런 것들을 concurrent 리스트에서 이렇게 연방정부, 중앙정부, 그다음에 또 같이 할 수 있는 이러한 법 제정의 어떤 관할이 이렇게 헌법에 의해서 규정이 되어 있는 게 특징입니다. 오케이? Shall we go to next?
Okay. Yeah. So we can go to the next. Separation of powers. Now, Indian Constitution again has three primary arms of functionality. One is legislation, another is the executive, and third is the judiciary. Now, judiciary's primary purpose is to enforce laws made by the parliament, legislation, and executive's primary purpose is to enact the legislation made by the legislatures. Now, there often arises conflict between the three arms of the government. They often try to, or often there arises a situation where one tries to encroach the power of the other. In these scenarios, the framers of our constitution very aptly separated the powers of the three organs so that they conflict with each other at the minimum. So Indian constitution have enacted roles, specific to legislature, roles specific to judiciary, and roles specific to executive, so that they do not encroach on each other's liberty and functioning. Whenever there is an overlap between the three branches, right? Whenever there is an overlap, the three branches have to work in coordination so that they can resolve the conflict, right? So judiciary, as has the power under the constitution to stop, restrict anybody from doing something which is unconstitutional, right? So it is a guardian, it is the body which is given the rights and duties to protect the constitution or violation of it, right, by any arm of the state, right? So if the parliament legislates on any law which violates the basic principles of our constitution, then the judiciary only has the power to strike it down, to review it, right? So the checks and balances. Similarly, judges do not appoint themselves. The legislature has a role to appoint judges. So one sense you can understand that the three arms hold each other's hand in a cooperative manner so that they can function and make India great in a sense, right? So that they do not violate the constitutional principles and do not conflict with each other, right? So these three arms worked in tandem to help India progress, right?
Okay.
So this is separation of powers.
Okay. 그 인도의 권력 분립이 그 대통령제처럼 이렇게 명확하게 행정부, 입법부, 사법부가 분리되어 있는 건 아닙니다. 의원 내각제의 특성상. 그런데 인도의 법체계에서 특히 사법부에서 특징적인 것들이, 인도 사법부는 그 주디셜 리뷰라고 해가지고서 그 법률 심사를 통해서 행정부나 입법부에서 만든 법이 헌법에 유연히, 그러니까 헌법을 위배되는지 안 되는지를 갖다가 심사를 함으로써 일정하게 그 입법부를 견제하는 그러한 특징이 있다는 거. 그런 맥락에서 전체적인 것은 법의 어떤 서로의 어떤 권력을 갖다가 이렇게 조화롭게 유지되지만, 또 사법부는 사법부대로 또 입법부를 또 견제하는 그런 독특한 그 특징이 있다는 것들을 특징적 그 설명을 주셨습니다. 오케이.
So you can go to the next slide. Now, since we are focused primarily on the legal system, we'll not talk about constitution more now. We'll talk about how the Indian legal system operates. So Indian legal system has a hierarchy of courts. The Supreme Court sits at the top of the hierarchy. It's the most important court in India. Below the Supreme Court, we have high courts. Now, each state has a high court. So High Court has the power to adjudicate all cases in that state boundary, and whatever decision it makes are considered to be rule of law within the state, where it is located or where it exercises its jurisdiction. Now, laws made by Supreme Court or reasoning made by Supreme Court is followed across India. So Indian territory, wherever and however it is, any law made by Supreme Court applies there. So, but for High Court, the boundaries are limited by the state in which it exercises its jurisdiction. So below the High Court lies the, group of subordinate courts, both for criminal matter as well as for civil matters. So we'll soon see hierarchical representations of the Indian legal system, in which we'll understand how the courts are in India are organized. But as of now, we need to understand that, the Supreme Court, then there are High Court, and then there are subordinate courts. And then there are various quasi-judicial bodies which make laws and adjudicate matters in the Indian legal scenario, right? So we'll go to the next slide and understand this much better. So this is the hierarchical division I was talking about. So if you look at this hierarchy, you will understand that Supreme Court, as I said, is the top most court in the country, then High Court, and then subordinate courts. And within these subordinate courts lies different types of courts for civil matters, for criminal matters, for revenue matters, for other things, right? So there are different branches now of subordinate courts to deal with different aspects of legal system, right? So if you see the civil courts are divided into district courts, then sub-judge courts, municipal courts, and courts of small matters. In the same manner, criminal courts have been divided into session courts, metropolitan judicial magistrate 1, 2, and executive magistrate courts. In the same manner, revenue courts have divisions. So what we mean to say is that since India is such a huge country with such a huge number of states and diversities to manage, so there are many types of legal issues coming in India. So this various branches of subordinate courts are there to look into the issues. Whenever issues are not resolved by the subordinate branches, then high courts are being approached. And if issues are not resolved at the high court level, then Supreme Court of India is, accessed or comes into play to resolve a dispute, right? So this hierarchy is very, very important in India, and this is how it is distributed, in its power and functioning.
Okay, so let me ask one thing. In Korea, Korea also same structure like hierarchy system in India,
Right.
but India is slightly different. According to civil court, there is a sub-judge, MUNSIF court. What is meaning MUNI?
Okay.
And
Munsif. This is called Munsif courts.
Munsif
Now,
court.
Munsif courts. So each district in India is divided into blocks, and then blocks have multiple towns in them, right, or villages in them. So so if there are petty matters, then they are resolved by courts of smaller causes, where there are petty disputes involving few thousand rupees, say, or small matters in between individuals or entities. If the matters are not resolved or beyond the jurisdiction of smaller courts, then you have a slightly higher up in the hierarchy, which is called municipal courts. These are block level courts, you can understand.
Okay, right. Okay. 지금 제가 질문한 것이 문십 법원이 뭔가라고 질문 드렸고, 지금 민사 법원에 대해서 지금 말씀을 드리는 건데요. 인도가 이제 이렇게 위계적인 한국처럼 뭐 대법원, 고등법원, 지방법원으로 되어 있는데, 이 지방법원 내에 또 이제 이렇게 그 디스트릭트 레벨이 있습니다. 디스트릭트 레벨은 이제 군 단위, 그 다음에 블록 레벨은 면 단위. 물론 이제 한국에서 생각하는 군과 면의 개념과 인도에서 보는 군과 면한 규모 면에서 엄청 다르지만 어쨌든 이러한 어떤 행정 체계에 의해서 문시프 코트는 이제 블록 레벨, 즉 면 단위 수준의 지방 법원이다, 이렇게 지금 설명해 주셨습니다. 그리고 이제 그 아래 더 이제 아주 미미한 그런 경미한 것들은 이제 그 아래 단위에서 또 진행을 한다, 이렇게 하고 그 이후에 또 설명을 듣겠습니다. Okay. Then next, what is the meaning according to the criminal court? 지금 형사법원에 대해서 질문을 하려고 하는데요. There is a
Sessions court.
class 1, yes, session. What is the meaning session court? And there is a class 1, there is class 2. What is the meaning different?
Okay, thanks for the question. See, at the civil court, as you understand, there are district courts. So which adjudicates matter at the district level, right? Which has multiple towns in it. Similarly, for criminal matters, the equivalent of district court in civil cases is called sessions court in criminal cases, right? So whatever is district court in civil case, you can understand it's an analogy for criminal courts at the district level. So they're the highest criminal courts below the Supreme Court. The High Court, right? So you know, if a matter is not resolved at the sessions court, it goes to the High Court of the concerned state,
Okay.
right? So they're the second in hierarchy in a state for criminal matters.
그 세션 콜트는 그러니까 이제 디스트릭트 레벨, 아까 우리가 민법에서 군 단위의 콜트라고 했는데 그거를 이제 세션 콜트라고 했고요. Then class 1 and class 2?
Yeah, similarly, you know, when criminal matters come, there are different categories of criminal offenses that take place, right?
Yes.
So if there are petty offenses, they're dealt with by executive magistrates, say, you know, and if there are offenses bigger than that, then judicial magistrate comes into play of class 2. So if the offenses are still of higher nature, then, you know, metropolitan or judicial magistrate of class 1 comes into play.
Okay, I see.
And so on and so forth. So there's a hierarchy, you know, of, you know, offense related, that decides which court you should approach.
Oh, yes, okay, I see. 그래서 지금 설명을 들어보니까 이 형사 재판은 이렇게 위계적으로 그냥 뭐 군면 이렇게 되는 것이 아니라 이제 그 군 단위는 이제 그 형사를 다루지만 이 형사 사건의 내용에 따라서 아주 심각하면은 클래스 1, 덜 심각하면은 클래스 2, 이거 아마 형량과 관련된 그런 범죄일 것 같습니다. 그래서 이거는 이제 그 군 수준에서는 뭐 이렇게 이제 형사 범죄의 어떤 그런 내용에 따라서 심각성을 가지고 이제 클래스 1이냐 클래스 2냐 이렇게 이제 다 나눈다고 합니다. Okay, and there is last question. And according to your presentation, there is a revenue court.
Okay.
Yes.
Yeah,
As a
so
Korean
these are
person,
land
we are
record
so much
courts, you know.
familiar with civil court and criminal court. We can understand very, very easily. But we don't have revenue court in Korea. So many Koreans couldn't understand that.
So revenue courts basically deal with land matters, you know.
Land
So
matters.
land records, land purchase, sale, and other things. Revenue is generally concerned with land holdings and land matters, right? So as you know, India was, pre-independence India, if you see, you know, so you know, before the British rule, India was ruled by smaller states, you know, there were kingdoms, you know, at various places. So land holdings was primarily, you know, with the king or the ruler, right? So when India got independence, there was a huge disparity in you know, land holdings and land matters. So this is how, you know, India deals with its land cases, you know. So revenue courts are, you know, courts which primarily have the function to deal with matters related to.
Okay, thank you. 지금 이제 설명이 랜드 리베뉴인데 이게 우리 학습책에서 형법, 민법이 있지만 이 재정법원이라고 좀 번역을 했는데요. 이 랜드 리베뉴와 관련되는 건데 인도는 그 영국 식민지 시대에 500개 이상의 프린슬리 스테이트라고 해서 봉건 왕들이 지배를 했습니다. 이들이 이제 영국에서부터 독립을 하면서 인도 국의 구성원이 됐는데요. 이들의 어떤 그 토지의 권리, 그다음에 그 시대의 어떤 왕과 소작인들의 어떤 관계에서의 소장료라든지 이런 어떤 여러 가지 복잡한 사례들이 굉장히 광범위하게 복잡하게 존재했었는데요. 이런 것들을 통합해서 다루는 그런 법원이 리베뉴 컬트라고 지금 설명드렸습니다. That is very interesting things. Okay, thank you.
So yes, yeah. So you can go to the next slide if you think.
Yes, shall we go to the next?
Yeah. So this is a description of what we just discussed. I think we can skip this slide. We talked about what Supreme Court's role is, what High Court's role is, what District Court does, and below courts, subordinate courts. So I think we have already had this discussion.
Right.
So we can go to the next slide if you so please. So now we come to the specific role of Supreme Court of India. So as we understand that Supreme Court is the highest court, you know, of the land, and its primary work is to settle disputes between different arms of the government, state government and union government, often, right? And as you know, in India, the irony is that the government is the biggest litigant. So if all Indian cases are analyzed, it may be that a significant portion of it, the government is one party to the case. So that means there are a lot of cases against and by the government, right? So Supreme Court has a very important role to play here, and it acts as a bridge between, often as a bridge between the people of India and the government of India in its various forms. So whatever Supreme Court decides, whatever Supreme Court rules becomes the law of the land instantly if it is not challenged and overruled. Now, Supreme Court is a court of record. What do you mean by that? Every decision Supreme Court is binding on the people of India, right, across its territory. So all the subordinate courts, including the high courts, have to follow the reasoning adopted by Supreme Court in a particular case, right? And that is why it is the most important court, right? So it has special powers. We'll see those powers soon, right? And we'll talk about some of the powers that it has.
Okay.
So we can go to the next slide. High courts. High courts are second in precedence after the Supreme Court. Now, high court are the highest court in any state, right? So at state level, they are the highest court. They are also court of record. That means any decision that the high court takes or makes in a particular case are binding upon all the lower courts within the state. And similarly, it can direct the state government and various arms of the state government to follow or not to follow certain practice that it may find suitable. So it settles disputes of all natures at the highest level in a state. So these are second in hierarchy, very important for the Indian legal system, right? So we can go to the next. Now, as I said, India has many diverse issues, and often the Supreme Court and the High Court form specialized courts to adjudicate matters of certain relevance or certain category. So we have under the Indian legal system the provisions wherein courts are set up to deal with specific issues, say family courts, the issues related to marriage, divorces, maintenance, guardianship, adoption, all can go into family court. Then there are special investigation bureau. They hold their own proceedings. They have their own judicial system, in place to counter corruption and bribery in government functioning. And similarly, often court forms tribunals, right, to deal with specific or a given category of cases, and so on and so forth. So in short, there are multiple specialized courts which may continue perennially, or they may be constituted for resolving certain things and then dissolve, right? So Indian Constitution gives this privilege to the Supreme Court and the High Court to form such specialized courts on need basis. So this is about specialized courts. We can move ahead. Next slide. So quasi-judicial bodies. Now, judicial bodies which perform judicial functions, but they are not judicial in the true sense of the word. So there are multiple such entities in India which operates as judicial entities. So one very important among them is the National and State Human Rights Commission to protect human rights. So often, as India is a land of diverse culture, as I said, often certain community, individual or entity may feel that their rights, human rights are being violated, so they can approach the National and the State Human Rights Commission for resolving the dispute. Similarly, to protect environment, there are national green tribunals, that has been formed, and they're playing a very active role in India for environmental protection as well as development. So what I mean to say is that they are not strictly judicial, but they are quasi-judicial bodies which role are very specific. So these are kind of extra courts that have been created, extrajudicial bodies that have been created to cater to specific needs of the Indian legal system. So we can go to the next, independence of judiciary. So this is the fundamental principle why Indian legal system thrives and continues to develop. So judiciary has been kept independent of the legislature and the executive. The framers of the constitution understood it very well, that if judicial power lies in the hand of the legislature or the executive, they can be subverted. So judiciary was given complete independence almost from the legislature and the executive. So judicial system in India is considered to be independent of the state. So they function independently so that they can protect its citizen and different entities that live in India from encroachments by the state, if any. Right. So the entire higher judiciary, has the power to punish any person for its contempt. Right. Similarly, it has the power to, scrutinize any laws made by parliament, any act of the state, and correct if it is in contravention to the principles laid down in the Constitution of India. That is only possible when judiciary is kept independent. So this is a very, very important aspect of Indian Constitution, in which judiciary is independent of the legislature and the executive.
Yes.
So judicial review, this is one such special privilege given to Supreme Court of India and High Courts to correct any wrongdoing by the state. So any act, any legislation that the state or any of its arm enact, the court has the power to review it, to examine it for various violations. And if it finds any portion or the entire law enacted by the state as violating the fundamental rights or other provisions laid down by the Constitution, then it can strike it down and ask the legislature to correct the error. Right. So judicial review is a very, very important functionality of the Indian legal system. Right. And this right has been given only to two courts, Supreme Court of India and the High Courts. Right. So High Court cannot, generally do not challenge the union laws. That is challenged generally in Supreme Court of India. High Court generally challenge the state legislation, right, or executive actions. So, but there is no bar on any High Court to examine a union law if matter comes before it, right? So this is Indian judicial review system, which is very, very powerful, and it is only exercised by two courts. Now, this again comes from the fact that legal aid is to support the legal process. Now, in India, not everybody has the resources to pursue long legal battles, whether they are between individuals or between individual and state. So legal aid is a very, very important concept in India, in which the state ensures that everybody gets a legal representation, right? So justice can only be given if the weaker have the resources or are given aid to present their case before the legal system, right? So, the Indian legal system ensures that nobody is unrepresented in a court of law. So it has provisions to provide free legal aid, free legal counsel, for poor litigants, right? So that their case is well represented before the court of law. So this is a very, very important aspect, which allows the poorer section of India to bring their case for judicial examination. So legal aid now comes in various forms, right? As I said already, it can be in the form of legal advice, legal representation, paralegal services. It can be in the form of law reforms. Awareness is also a very important aspect of legal aid. And then a very important arm which has been very functional over the last few years is called the alternate dispute resolution. So, instead of going to court, there are various forums which counsel, which try to resolve dispute between individuals and entities, through dispute resolution mechanisms. So this is also part of the legal aid. So legal aid in India comes in very, very different forms. When there are pressing issues of any community or entity, then public interest litigation has been one of the very prominent methods by which courts have ruled in favor of the litigants in many such cases where through public interest litigation, a lot of matters have been settled, which affects a large section of Indian population, which is poor and does not go to court generally. So yes, legal aid has been a very, very enabling provision in the Indian legal system. So to ensure that legal services are available to all, there is a body which is called National Legal Services Authority, which has been set up in India, right? This is an apex body to formulate policies, to lay down provisions in which legal services, especially legal aid, can be given to the vast poor population of India, right? Say this is a very active organization which organizes camps, awareness camps. They give legal advice. They give often representation to poor litigants so that they are well represented in courts, and their cases are resolved without going through the rigor of the long and costly legal system that India has at present. So this is a very important organization in India, National Legal Services Authority. So as I talked about free legal aid, so we have already talked about this. This is to enable poor, litigants in India to have their case represented in the in the court of law. So this body ensures that people belonging to marginalized section of the society can get represented in the court of law. So this is free legal aid that is available in India. As I talked about this again, alternate dispute resolution mechanism is a very, very effective tool that has reduced the burden on the court significantly, especially to resolve matters which are trivial, petty, but often create nuisance in the life of people. So, neighbors dispute related to parking, say, dispute related to matters which are trivial for a community. These can be resolved by alternate dispute resolution mechanisms, by which the burden to reach court, follow the rigorous process of judicial system is curtailed, and disputes are resolved so that it maintains social order and harmony among uh, its people, right? So this has been very effective, and the Indian entire legal system promotes that people go to alternate dispute resolution forums to resolve their dispute before they approach the court, right? So this is very, very effective mechanism. We can go to the next slide. Okay, then as alternate dispute resolution mechanisms are non-judicial forums, largely they're counseling forums. In the same manner, these lok adalats or people's court, as we call it, are often constituted once in a month, twice in a month at times, right? If the need be, it can be constituted in 15 days a month, once in a fortnight. So what it does is that it resolves petty matter then and then. So judicial officers sit with all the cases that are listed, and the parties are called, and they are made to negotiate and resolve their dispute then and then. So it is a very fast mechanism or dispute resolution. Say traffic challans or tickets for violation of various traffic rules comes here, and whatever fine has been imposed upon a person or an entity, he's asked to negotiate and resolve the matter then and there. So instead of going through the legal and entire process of resolving a dispute, this Lok Adalat again helps to reduce the burden on the courts, right? And results in faster dispute resolution. So this is again very effective mechanism in petty offenses. So now, as you know, India went global in its economy in 1993. Now, United Nations were formed after effect of Second World War, as you all know, to bring peace and harmony among nations internationally. So now international laws are formed related to commerce, related to human rights, related to different aspects of international cooperation and harmony. So these international laws have a great effect, enabling effect on Indian legal system. So it often guides the courts in India to resolve disputes. So Indian legal system often takes inputs from international sources of law, right, to resolve its domestic as well as international disputes, right? So this has a very important effect on the laws of India. So there was a comment. I'm not sure what is written in the comment. If you can quickly tell me if there is something for me to act upon.
Sir, let me give me a break. Some
Yeah.
of our audience asked me, it's slightly boring. Boring means the term of law is not so easy to ordinary people. That is why
Yeah.
some audience
Yeah.
to feel some boring. So before go ahead, I would like to summarize little your point. Okay? Yes.
Right.
To share your lecture more easily. 지금 강의 중에 채팅이 올라왔는데 조금 법률적 내용이다 보니 이렇게 좀 어렵다 이런 표현을 했는데, 그래서 좀 강의 중간에 제가 조금 이렇게 좀 쉬는 시간을 가지면서 지금 이제 왜 이게 이제 인도 법률이 중요한지에 대해서 조금 더 이제 부연 설명을 드리면 아무래도 이제 이해가 될 것 같습니다. 그래서 지금 우리가 인도를 이해하는 데 있어서 기본적인 법칙이나 이런 것들은 우리 법 지식을 통해서 우리가 보는데, 특징적인 것은 인도 헌법이 있는데 여기에는 사회주의, 세속주의, 민주공화국을 설명하고 있는데 그러면서 그러면서 기본권을 굉장히 강조하고 있는 헌법 체계라는 거죠. 그리고 이러한 헌법의 근거에서 이제 그 권력이 이제 분리가 돼 있고 견제하는 그런 시스템이고, 이 중에서 이제 지금 현실적으로 지금 와닿는 부분들이 그 인도 대법원인데, 인도 대법원은 그 주디셜 리뷰라고 해가지고서 그 인도 그 사법 심사를 통해서 굉장한 막강한 힘을 갖게 돼서 이러한 것들이 인도 민주주의 활력을 주는 그런 부분인데, 이번 강의를 통해서 그 다음에 이제 인도에는 이러한 그 위계적인 대법원, 고등법원, 지방법원 이런 위계적인 법체계가 있음에도 불구하고 또 특별법원을 통해서 굉장히 인도의 그 다양한 법적 분쟁들을 해결한다라는 것들을 좀 우리가 오늘 강의를 통해서 새롭게 알게 되었습니다. 그래서 일반적으로 대법원, 고등법원, 지방법원이라는 그런 위계적인 구조뿐만 아니라 이런 특별법원이 있고, 더더군다나 이 준사법기관들이 사실상 사법부는 아니지만 사법부에 준하는 어떠한 역할들을 하고 있다는 게 굉장히 그 특징적입니다. 그래서 특히 이제 국가녹색재판소라는 내셔널 그린 트리뷴이라는 이런 어떤 사법기관은 아니지만 사법적인 그런 기능까지 하는 이러한 기능들이 인도에서 활발하게 활동하고 있다는 것들을 우리가 알 수 있었고요. 사법부의 독립은 뭐 중요한데, 이 부분이 이제 조금 이제 우리가 짚어봐야 될 대목인데, 인도의 법체계는 워낙 방대하고 복잡하기 때문에 그 법률 소유를 다 수용할 수가 없죠. 그래서 이런 것들을 재판을 통해서 다 해결을 못하니까 이제 법원 심사나 이제 재판 과정이 길어지고 또 그 다양한 그 케이스에 대해서 대응을 못하다 보니 이 법적인 어떤 소외계층, 이 법적인 약자계층이 있는 거죠. 그래서 이런 것들을 이제 구제하기 위해서 구조 시스템이 많이 발전이 되어 있는데 이게 총체적으로 내셔널 리걸 서비스 어설러티라고 하는 이런 당국에 의해서 이런 것들이 이제 그 구제가 되는데 우리나라로 말하면 법률 구조 공단 뭐 이런 측면이 되겠죠. 근데 우리나라의 법률 구조 공단은 굉장히 좀 형식적인 측면이 있거든요. 그런데 인도는 그렇지가 않은 특징을 보여주는데 예를 들면은 락카달스라고 하는 이러한 그 독특한 제도가 있는데 이게 보니까 1987년에 그 이런 이제 제도가 이제 만들어졌다고 합니다. 그래서 이런 락카다를 통해서 분쟁 뭐 해결을 하는데 우리나라에서는 국민참여재판이라고 해서 이게 법원이 일정한 그 뭐라고 해야 될까 국민 그 권한을 이제 회부해서 토론을 해서 어떠한 이제 결정을 내리면 이거를 이제 판사가 인용할 수도 있고 또 거부할 수도 있습니다. 그래서 어쨌든 최종 판단은 이제 사법부에서 하게 되는 건데 여기서는 그렇지 않다는 거죠. 물론 심각한 어떤 형사라든지 어떤 국가 행정과 관련된 이런 거라든지 이런 것들은 이제 공식적인 사법 체계에서 하지만 그렇지 않은 다양한 형태의 그 민법, 관습법 이런 것들은 라카달에서 하는 겁니다. Sir, today especially we had learned regarding lakadars. So can you explain more lakadar and okay, sorry. 지금 시간이 없어서 이걸 가지고 조금 설명을 좀 요청하면 좀 그러니까 okay, so let me go ahead and so we listen for your lecture, then we can discuss later. Okay, so now we are
Right,
going
that may be wise, yeah.
because we have no time. So to use our time effectively, so first of all, we want to listen your lecture. 자, 그래서 시간이 없으니까 먼저 교수님 강의를 듣고 우리가 또 이런 거에 대해서 좀 더 이후에 좀 더 설명을 들어보도록 하겠습니다. Okay, so now we are going to the issue with judicial system structure. 자, 지금부터 이제 이러한 문제들이 뭔지 한번 들어보도록 하겠습니다. Okay, shall we go?
So as we understand, the judicial system is not free from a lot of issues, right? So the biggest issue plaguing the judicial system of India is its vacancy, right? So each court has a strength, right? The number of judges that it should have to adjudicate on matters. And if you see the table, we can show, most of the courts are functioning of around 50% of its capacity or below. What it means is that they do not have enough people to adjudicate matters, right? And if this continues this way, then the pendency is only going to increase, right? And if you see point number 4, you'll see that, there are, just 10 to 11 judges per 10 lakh people, 1 million people, right? That says that, we have a skewed ratio. We have very less judges to adjudicate upon issues that arises in India, right? And then if you look at the bullet points, corruption, it's not that judiciary is free from corruption in India, right? So it's not possible generally to register even an FIR without consulting the Chief Justice of India, for officers after a certain rank. That means, we have corruption in judiciary, we know, but it's very difficult to bring, judges to books. It's very difficult to prosecute them under the system, right? Or establish charges against them often, right? Similarly, there's a lack of transparency in appointment of judges. Appointment of judges has been a contentious issue in India right from the start, so who will appoint judges and how should judges be appointed so that the system can be fair? It has been a long debate that is going on and on in India. So right now we have a collegium system in place wherein, three, senior most judges, including the CGI, recommends names of judges for appointment in higher courts in India, which the legislature committee approves or disapproves, right? So the idea is that the judiciary has its own issues that it has to sort out so that Indian legal system can evolve and get better or more efficient, right? So these are some of the issues that with Indian judicial system structure, and we can see some more in the next slides.
Okay, so what is the meaning sanctioned strength? Vacant post I can understand, but sanctioned.
Okay. So every high court has been allocated certain number of judges by the government, right? So say High Court of Delhi has about 60 judges, which is the strength of the court. Now the actual functioning is being done by 29 odd judges. Right? That means there are 31 vacancies or 29 vacancies, right? So they're operating at 50% of its strength, you know. So these are number of posts. Sanction strength means number of posts. So in your university, say in your department, there are 10 posts and 5 people are working. And 5 people are working.
생션 스트레스는 60명의 이제 그 판사가 필요한데 지금 공석이 29석 이런 의미입니다. 그러니까 지금 이제 판사의 공석, 그러니까 인력이 워낙 인도가 방대한 국가에서 판사의 수가 압도적으로 적고 여기서 나오는 여러 가지 뭐 부정과 부패도 있다 하지만 구조적으로 이러한 그 판사의 수 부족이 큰 문제라는 거죠.
Now, this is a very sad scenario for the Indian legal system. This shows you a snapshot of the number of under trials that are in India. So that means, you know, of the entire prison strength, if you see, the significant portion of people are under trials. Under trial means people whose trial is not complete. They have not been convicted or, you know, released, right? So their guilt has not been established. Still, they are lagging in jails. So of the total prison population, if you see around 60% or more is under trial, right? This says that in India, the legal system is not very efficient to resolve issues, right? More time period than for the felony that they have, you know, they are alleged to have committed, right? Because they're under trials, you cannot say that they have committed. They're alleged to have committed. So this is a very sad affair in India. And if the data is analyzed properly, we'll see that most of them are from the marginalized section of the society, poor section of the society, who cannot afford legal system.
Okay,
so though we have provisions of legal aid, though we have provisions of free legal services, still it is not reaching the entire, you know, set of people who need such assistance. And that is why we have such a huge population languishing in Indian jails without trial being completed.
Okay, sir, give me 1 minute to explain your explanation. Okay, 지금 이제 이게 굉장히 중요한 이제 부분인데요. 우리 그 김영환 선생님 지금 인도 법체계가 좀 복잡하고 재미가 없다고 그러시는데요. 우리가 이제 이러한 이제 기본적인 이제 인도 법체계의 특징이나 여러 가지 좋은 점 이런 것들을 했는데 실제 이제 어떻게 이게 진행이 되는가 이게 이제 중요한 건데 굉장히 이게 이슈가 되고 있습니다. 지금 이 도표가 아주 단적으로 보여주고 있는데요. 인도는 이렇게 좋은 법과 여러 가지 제도가 있지만 실제 재판 과정은 길어진다는 겁니다. 그래서 여기 도표가 뭐냐면 델리 같은 경우는 컨빅트가 3,388건이 이제 판결을 하고 있는데 지금 재판이 진행되고 있는 게 10,000건 이상이 됩니다. 이런 식으로 각 주마다 이렇게 이제 실제 그 판결보다 재판 진행되는 수가 훨씬 많다는 거죠. 어떤 일이 벌어지냐면 판결에서 예를 들어서 3년 선고를 받은 사람이 재판이 5년이 걸리는 겁니다. 이렇게 되면은 재판은 3년형을 받았는데 실제는 5년을 징역을 살게 됩니다. 재판이 지연되면서. 대한민국은 이게 이제 1심에서 6개월, 2심에서 6개월, 3심까지 최소 1년 6개월까지 끝내야 되는 어떤 그런 의무조항이 있기 때문에 이게 가능한데 인도는 워낙 인도가 그 인구가 많기 때문에 사건도 많기 때문에 이게 큰 문제가 된다는 거죠. 그래서 이 도표에 보면은 지금 여기에 4.78 락이라고 하는데 이게 47만 8천 건의 그 명이 이제 예를 들어서 그 확정 판결을 받아 수감되어 있는 인원수인데 무려 33만 명이 재판 진행 과정이기 때문에 그러니까 형이 확정받지도 않으면서 구속된 상태에서 일단 있는다는 얘기죠. 이러다 보니까 그 법률적인 어떤 그 서비스가 굉장히 질이 떨어진다는 거고 우타르프라데시 같은 경우가 이게 이제 그 재판이 지금 진행되고 있는 지금 위에 있는 이 33만 명의 사건 중에 이 73,418건이 이제 진행되고 제일 크고 그다음에 비하르, 마하라스트라 이런 데서는 이제 엄청나게 그러니까 그 재판이 진행 중인 게 적치돼 있다는 거죠. 그래서 이러한 총체적인 좀 인도 법률 행정의 어떤 취약 이런 게 지금 심각한 문제라는 겁니다. 오케이.
So what is the road ahead? So the idea is, how can we make our system more efficient? So the first thing, it should be that, every court should have at least as many judges at it should have. So if we appoint more people and fill up the vacancies that lie in the Indian courts, that will help expedite the functioning of the court, make it more efficient. Similarly, formation of more tribunals, formation of more quasi-judicial bodies to resolve specific issues and to stop appeals from that. What happens in India is that the quasi-judicial tribunal, say, resolves a dispute, then the parties approach the court again, say that we don't agree with the resolution, and now so the legal system is burdened again and again by the legal process, because an aggrieved party can always approach a court, right? So if we restrict appeals from tribunals, from quasi-judicial bodies, and we take their resolution largely as the final resolution, then the load on the court reduces. Similarly, enabling of technology due to this COVID-19 has resulted in a new dimension in the Indian legal system. Now, the courts encourage virtual hearings, the court encourage virtual sittings, right? Where the court's efficiency has increased by many times by hearing matters off schedule times in the court, and often involving parties which are located far away, right? So the idea is that if we enable more technology, if we enable more AI based solution to come up with how the court should approach a given legal case, the system, Indian legal system, can be made more efficient. So this is how India believes that it can move forward with its present issues. So now this is Bar Council of India. A slide on Bar Council of India is very important on any discussion on Indian legal system. Why it is so? Because Bar Council, as we understand, controls the entire body of lawyers, advocates, and legal education in India. So every person who wants to enroll themselves as an advocate has to enroll themselves, get a license from the bar. Now, bar are organized again in the federal way in two levels, state level as well as the union level. So you have an all India bar and you have a state level bar. So every person who wants to become an advocate in India has to obtain a license and enroll themselves in one of the state bars, right? And that is how the Bar Council of India operates. It's the body of all the advocates in India, and it also controls the legal education in India. So the entire legal education in India is supervised by the Bar Council of India, right? So it is an body which has been created by the Act of Parliament to regulate and represent the Indian bar, and it has a very important functioning in the entire legal system. So any presentation on Indian legal system, Bar Council requires a special mention. That is why it is here. So this is a snapshot of one of the arbitration center to resolve not only disputes arising in India but internationally. This has come up in Hyderabad, a very prominent city in India. So this is an arbitration center, and the right side photo is of the new ways to adjudicate matters in virtual settings is being given to give you an idea how Indian courts are now operating in virtual manner, where parties, the advocates and the judge, all of them come together in a meeting like the one we are having and try to adjudicate matters. So this is how India is using technology to enhance its efficiency of legal system. So in conclusion, if we try to conclude, we'll say that India has a very rich and very diverse and complex legal system. At the same time, there are issues with the legal system which needs to be sorted out so that India becomes a more vibrant democracy where rule of law is more prevalent than it is now. Having said that, the Constitution of India is a very rich document which enables the Indian state, Indian judiciary, Indian citizens, obey and follow the rule of law. And we, as Indian citizens, believe that all of us are bound and guided by the Indian Constitution to make India a great country, right? So if we resolve certain challenges of Indian legal system and come up with more dynamic and improvised solutions to reduce the burden on Indian courts and implement the rule of law in all aspects of Indian scenario, then our legal system will become more efficient and will be a better state. So with this, I end the presentation here and initiate the time for discussion if there are any topics to do so.
Okay, thank you so much. That is very wonderful presentation. So before we are conclude, let me summarize your lecture for Korean audience. Give me 1 minute. So just hold on, please. 자, 그래서 이제 이러한 문제들이 이제 많이 있어서 이제 우리 아그라왈 교수님은 이게 이제 본인의 이제 사실은 그 고민인 거죠. 그래서 이러한 고민인데 이제 인도 법원도 이런 적체 현상, 그 여러 가지 그 법률적 분쟁이 자꾸 늘어나겠죠. 지금 인도가 굉장히 빠른 속도로 이제 경제화가 되면서 이제 경제적인 어떤 불평등 문제뿐만 아니라 여러 가지 사회 문제들이 굉장히 많이 일어나고 있습니다. 그래서 이런 것들을 이제 수요가 늘어나기 때문에 이런 것들을 이제 어떻게 할 것인가 이런 고민을 하는데 특징적인 것이 유튜브로 이제 스트리밍으로다가 이제 생중계한다는 얘기를 이제 저도 처음 들었습니다. 그래서 저도 이 점이 좀 굉장히 신선했고요. 일단 대안적인 그러한 어떤 법률 체계를 위해서 이러한 그 virtual court, 가상 법정에서 이렇게 판사들이 뭔가 이제 의논을 해서 이제 신속하게 뭔가 처리하고자 하는 이러한 모습도 있다. 그래서 이런 걸 보면서 인도가 여전히 어떠한 그 이러한 문제들, 즉 이렇게 그 펜딩 돼가지고 이렇게 지체되면서 재판이 지체되면서 여러 가지 좀 문제가 있지만 이러한 그 virtual 시스템이라든지 그 다음에 더 재밌는 것은 이러한 그 라카달 같은 이런 여러 가지 위원회, 형식적인 우리 대한민국에서는 어떤 형식적인 국민재판이 아니라 실질적으로 재판에 이렇게 그 위원들이 참여해서 분쟁 당사자들이 와서 토론을 하고 여러 가지 의견을 들어서 이제 조정을 해서 어떤 해결을 하는 이러한 것들은 상당히 인도 법체계의 어떤 유연성 이런 것들은 참 우리한테 좀 새로운 모습을 보이는 거고요. 우리가 인도 자체에 대한 법체계를 전문적으로 깊이 알 필요는 없지만 인구 14억이나 되는 이런 어마어마한 그런 그러니까 큰 규모의 국가가 법률적인 것들을 갈등을 해결하기 위해서 어떻게 지혜를 모으고 있는지 실제 어떻게 하는 건지 이런 것들 이모저모 따져보면서 우리가 인도에 대한 어떤 더 좀 깊이 있는 이해를 도모해 볼 수 있지 않을까 이런 생각을 합니다. 그래서 오늘 그런 취지에 대해서 개략적인 어떤 법률적 지식보다는 이런 현황에 대해서 우리가 좀 살펴보았는데요. 아까 그 어떤 참가자분께서 좀 너무 좀 딱딱하다 이런 말씀을 하셨는데 지금까지 좀 이야기를 듣고 좀 편안하게 좀 혹시 궁금한 점이나 이런 질문에 대해서 우리 강의에 참여하셨던 분들 좀 의견을 좀 듣고 또 제가 또 한두 가지 질문을 하고 좀 마무리할까 합니다. 질문 있으시면 마이크를 켜고 아니면 채팅창에 올려주셔도 되는데 질문을 좀 해주실까요? Okay, so anybody who want to make a question or answer and suggestion, please come join us. Anybody? Otherwise, if there is some difficult, 혹시 강의 내용 중에 좀 이해하기 어려운 부분 있으시면 또 질문해 주셔도 됩니다. If there is some difficulty to understand, then you can also ask to us.
Right.
Nobody? Yes. 김영환 선생님 아까 채팅창에 좀 어렵다고 했는데 혹시 뭐 질문이나 이야기할 수 있을까요? 이창원 선생님 꾸준히 오시는데 Yeah, there's no question. So,
Okay.
so today, yes, yes, as Koreans, it is not so easy to understand perfectly, but even though this is a very, very important topic to approach, to go ahead, understand Indian society through legal system. Yes.
Right.
So especially from your explanation today, you had learned some problem of Indian legal system, especially there is a very lack of the judge, so the pending under trial is very huge, so there's some gap. So overcome that situation, India has a very, very special effort to overcome these things. Especially you had mentioned it, Lakadars and virtual court. This is very, very interesting. So can you explain on your opinion regarding legal system as a conclude? Totally before to take a lecture. So through this lecture, what did you want to convey to Korean audience throughout your lecture? So what is your intention?
Okay. So see, one is that.
Okay, just one minute. 자, 그래서 제가 드린 질문은요. 이번 그 강의를 통해서 여러 가지 인도의 법적인 한계를 얘기했고 또 특별하게 오늘 교수님께서 그 버추얼 코트 가상 법정에 대해서 얘기했는데 오늘 강의를 통해서 우리 교수님께서 우리 한국의 참가자들한테 하고 싶은 이야기가 뭔지 제가 질문 드렸습니다. Okay, go ahead, please.
Yeah. So the first thing that we'd like to say is that India is a land of diversity that most of the world now knows about India. And so Indian legal system has a deep respect for diversity of culture, religion, language, caste, creed, everything. At the same time, there's diversity in resources available to Indian population. So a huge section of Indian society is poor and a very small fraction is privileged to have all the resources in India. So there's economic disparity in India, right? And this is one of the very big concern of the Indian government, how to distribute its resources and lower, the poverty levels of the Indian population. So if the Indian population is educated more, the poverty is reduced, the dependency will also go, right? And so it's not only the legal system which has the responsibility to resolve, the issues. The Indian society as a whole has to come up, and act together to bring its system in place, make it more efficient and available to all, right? So yes, we have to all play a role together to enable the Indian legal system to become more efficient and more robust and available to all Indian citizens.
Right. Yes, right. 자, 우리 교수님의 의견에 저도 전적으로 동의합니다. 뭐냐면 우리가 이제 법을 얘기하기보다 이렇게 방대한 다양한 인도 사회를 이해하는 데 있어서 법이 인도 사람들의 어떤 영향을 미치고 있고 여러 가지 상호작용을 하고 있는 거죠. 그래서 기본적으로 이러한 법이 어떻게 이제 인도 시민들한테 작용을 하고 있는지 이런 것들 요모조모 살펴봄으로써 우리가 인도 사회를 좀 더 이해하는 데 있어서 법률적 이해는 필요하다. 이런 거에 대해서 저도 전적으로 동의하고. Yes, perfectly. I agree your opinion. 그래서 예를 들면 그렇습니다. 우리 한국의 많은 기업들이 요즘에 인도에 가는데 덮어놓고 인도의 뭐 사회 문화는 뿐만 아니라 법률에 대해서 무시하고 가는 경우가 많아요. 즉 어떠한 어떤 문서로 되어 있는 어떤 계약서만 가지고 가서 뭐 공장에 투자를 한다든지 엄청난 돈을 투자를 하는데 인도는 관습법이 있다고 했지 않습니까? 또 준사법기관도 있는 거고. 그러니까 이런 여러 가지 어떤 것들을 이해를 못하고 가서 낭패를 보는 경우가 많습니다. 그런데 그렇게 투자한 사람들은 인도 사람들을 굉장히 불신하고 인도는 법을 지키지 않고 뭐 이렇게 얘기를 하거든요. 그렇지만 인도는 굉장히 나름대로의 내부적인 그런 시스템이 있는 거거든요. 우리가 그거에 대한 무지에 오는 어떤 그 편견에서 갈등이 생기는 건데 그런 것들을 모르고 인도는 무법천지다부터 시작해서 인도에 대한 어떤 오해 그런 것들에 대한 어떤 갈등이 많이 됩니다. 그래서 오늘 이 시간을 통해서 우리가 인도를 이해하는 데 있어서 단순히 법률적 지식을 쌓는 것뿐만 아니라 이런 법률들이 어떻게 인도 사람들한테 영향을 미치는지에 대해서 우리가 알고 오늘 얘기를 통해서 뭐 대법원, 지방법원, 고등법원뿐만 아니라 또 관습법, 또 여러 가지 준사법기관 이런 것들도 요모조모 알아보고 특별하게 오늘 또 인도에 대한 어떤 이 법률 체계의 한계들, 문제들에 대해서도 우리가 깊이는 아니지만 이런 또 인도 법칙에도 한계가 있다는 것들을 이제 알면서 우리가 좀 더 인도 사회를 알기 쉽게 또 좀 더 깊이 있게 들여다볼 수 있는 그런 기회가 될 수 있는 것 같습니다. Yeah, because of your uh, help to explain very, very shortly, we can conclude within on time.
Okay, I'm happy to
So
have that. Yeah,
yeah,
I'd like
I'm
to add, if you allow me,
yes,
that
yes.
with all the challenges and all the issues that exist in any legal system and in Indian legal system in particular, I must say that Indian legal system has evolved itself to match the best of the legal system present in the world. And it is often quoted, its judicial reasoning is often quoted in UN, US, Australian courts, and they take clue from how India resolves its conflicting issues, you know. So India has the finest set of brains operating as judges at the higher judiciary and lower judiciary, and set of excellent advocates who advocate, preside and adjudicate matters, help in adjudicating matters as judicial officers of the court, involving complex and very important issues, right? I see very bright future for Indian legal system to evolve and become more efficient in the
Okay.
coming future.
오케이. 그 교수님이 그 인도의 법체계가 여러 가지 뭐 약점도 있고 한계가 있지만 이 시스템 자체는 굉장히 그 안정적이고 합리적이기 때문에 오히려 국제사회에서 굉장히 인도의 법체계에 대해서 관심이 많고 저도 제 의견을 okay, I'm yes, right. Your comment is correct. I'm agree. Yes, yes, perfect. Right. 그래서 저도 지금 교수님의 의견에 동의를 하고요. 특히 이제 인구 14억이나 되는 많은 사람들이 또 지난번에 우리가 이제 이야기했듯이 이런 다양한 그러한 문화와 언어와 이제 그런 내용을 가지고 하는 사람들이 그래도 어떻게 법률적으로 이렇게 조정해 가고 해결해 가는 그런 방법, 이런 논리적인 이런 틀들은 상당히 우리가 좀 우리의 갈등 문제들 해결하는 데 있어서 좀 참고해 볼 만한 그 의미가 있다. 저도 그렇게 생각합니다. Yes. 우리 그 만주 아그라왈 교수님은 지금 한스라지의 컴퓨터학과 교수님입니다. 델리 대학교. 그럼에도 불구하고 이제 석사를 그 법을 공부하셨거든요. 굉장히 스페셜한 그 경험인데요. Okay, sir. This is last personal question.
Okay.
You are belong to the computer science department in
Right.
Hansraj College, isn't it? In Delhi University.
Right.
As a computer science scholar, you give a lecture regarding Indian legal system. This is a very unmatched and unusual lecture. So let me ask last question. Even though as a computer science professor, you did not give a lecture regarding computer science. Instead of computer science, you give a lecture regarding Indian legal system. Why?
Okay, I have recently developed interest in the study of legal systems in India, and I have just completed about 2 years back the LLB program, BLLB program, which is very tough and competitive at the University of Delhi. So my interest lies into enable technology-based solutions
Oh,
to Indian legal system,
wow,
right?
wonderful. Yes, yes.
So I'm working on those at a preliminary stage to how to enable technology help Indian legal system overcome its pendency,
Okay.
of cases, and that is why my interest in Indian legal system and
Oh,
its challenges.
it is very impressive comment because most of the experts only stress on his own field. Suppose I'm a political scientist, then I'm stressed on only political perspective. But you have very huge viewpoint, outlook. very wonderful. 우리 교수님은 컴퓨터 사이언스 교수님이지만 불구하고 이러한 그 자기의 컴퓨터 관련 공학이 인도의 법체계에 도움이 되는 데 있어서 기여를 했으면 좋겠다. 이게 참 인도 IT 강국인데 이게 이렇습니다. 인도의 컴퓨터학과 교수가 지금 법 강의를 했는데 저도 처음에 이걸 동의를 할까 말까 망설였습니다. 그럼에도 불구하고 이제 워낙 학부에서 그러니까 석사를 이제 법을 공부하셨기 때문에 동의했는데 이게 인도의 특징인 것 같습니다. 우리 컴퓨터과 교수 보고 법 강의 하라고 못 하거든요. 그러니까 이러한 것들이 IT 강국이 이러한 창의성 이런 것들이 또 굉장히 스페셜한 것 같습니다. 그래서 오늘은 특별하게 okay, so sorry, we are going to conclude. We have a short time, so
Thank
we have
you.
to conclude. 자, 그래서 지금 우리가 시간이 없어서 이제 또 정리를 하겠는데요. I'm so much appreciate with your lecture, enjoying our citizenship lecture. So we try to make another opportunity to invite on listen your lecture. 자,
I'll be happy. I'll be glad to participate.
이렇게 더운 날씨에 또 이렇게 시민 강좌에 참여해 주신 우리 참여하시는 분들 감사드리고요. 다음 주에는 이제 마지막입니다. 다음 주 시간에는 마지막으로 이제 제가 하는 그 인도 자본주의 고도화와 농민층 분해를 중심으로 이제 마지막으로 이제 하겠습니다. Okay, thank you so much. You are going to
Thank
conclude.
you. Have a
See
great day.
you. Okay, have a good luck. Thank you.
Bye.
자, 오늘
Bye.
이것으로 인도
Thank you.
시민 인문학 강좌를 모두 마치겠습니다. 감사합니다. 나마스테. 바이바이. 강 선생님 안녕히 계세요. 오늘 참여해 주신 모든 분들 감사합니다. 네, 안녕히 계십시오.